So I'll start welcoming everyone as you jump in on the webinar. We'll give it about a minute to get everyone on before we jump into the content. It's a very fun panel lined up. We've had a couple meetings as we've been preparing for this, and I must tell you the amount of jokes and how funny this crew is. This will be entertaining as well as a lot of fun content for everyone here today.
I think most of the jokes were from you, Gary.
So I'd like to hear myself talk. All right, fair enough. That was a joke, everyone. But when you're having topics like this, they're not they can sometimes be dry. So you have to find ways to make sure that they're also entertaining in the process. And we do our best. We were also talking about World Cup just before. It's like the people we had to make sure the webinar started right after the 10 o'clock game ended, and we're like, what happens if they go into overtime? What happens if they go into penalty? Then there's going to be live chat updates on the webinar letting people know what happens. So hopefully not everyone here is huge soccer fans, because I don't think we have a conclusion on the current game yet. So although I guess if they're huge soccer fans, they haven't come on the webinar just yet. So
Gary, we can add a little ticker at the bottom or in the chat just with updates if there's scores or if it goes penalty kicks or anything like that. Perfect.
Well, every time you put these webinars together, there's a team making the magic happen on the back end. So Raquel and Amanda, that are the hidden magic behind what you see here today, can be the ticker and say, Morocco won or Spain won. I'm not picking favorites for anyone in the audience. I don't want to start problems during the webinar, but I will jump into it. I know I see the numbers keep popping up. So for the purposes of getting us going, I will start with some introductions. I'll get the group here to introduce themselves before we dive into the content. And obviously, to the extent that new people jump in, then by the time the introductions are done, we'll go right into the content. Now, I will pick on people based on the order I mentioned, based on alphabetically based on the first names, which means Jenna would get to go first, and then we'll go to Mike, and then we'll go to Sarah, and then to Stephanie. So without further ado, Jenna will start with an introduction for yourself, and I'll be last.
Thanks, Gary. So thank you, Gary, and to the Baker team for inviting me to participate in this panel discussion. And thank you so much to all of the attendees for joining during this really busy time of year. I'm Jenna Kramer, and I'm legal counsel for Unilever Canada.
Thank you, Jenna. And we'll go on to Mike next.
Thank you, Gary. And also thank you to the Alexa team for putting this together and for hosting. My name is Michael Rubinger. I'm a senior associate at Baker McKenzie, and my practice focuses primarily on patents and trademarks, as well as brand management, portfolio management, and transactional and advisory work. And I'm very excited today to talk about this Bill 96 topic.
Mike. And we'll go on to Sarah next.
Hello, everyone, and I'm really excited to be here today and echo what Mike said. Thank you to Alexa for planning this panel. So my name is Sarah Mavula, and I'm an associate at Baker McKenzie. I have a split practice doing transactional and advisory work, but on the advisory work, I do marketing, advertising, and product compliance. And so I'm really excited to kind of talk about the ins and outs of French language laws in Quebec.
Thank you, Sarah. A lot of the audience is very excited about this as well. And Stephanie.
Thank you again, Alexa and everyone, and thanks for inviting me to participate as well. I'm Stephanie Vicari. I head up the IP Tech group at Baker McKenzie. I've been at Baker for over, I'm not even going to disclose the amount, but over 20 years, let's just say. And my practice is also split, but it's predominantly trademark related. I do the transaction and litigation side of things.
And I'll introduce myself last. Gary Kalati, I'm the CEO at Alexa Translations. For those of you that have been attending our series, being this is our first session, I've been the host, and I'm a lawyer by trade. So some of the topics here I've been very excited about in my own nerdy way that never dies out, despite being far more on the business side these days. So without further ado, I know a lot of the guests that we're expecting are here, and certainly we'll give quick recaps as we further go into the session. But let's start with a little bit of background, opening it up to all our panelists here. So, especially for those that are attending this webinar for the first time and they haven't been to the other parts of our series, what is Bill 96 and what is this Charter of the French Language? So give us a bit of background on this before we dive into the specific items for today.
So I can take this one on. And, before we can really talk about Bill 96, I think it's important to really have a good idea of, how it came to be in the very first place. So I'm going to give you guys a really short history lesson. So first thing, what may surprise some of you is that up until relatively recently, French was not the official language of Quebec. So it was only in 1974 that the Quebec Liberal Party brought in Bill 22, and that made French the official language of the province. So this then paved the road for the Parti Québécois to be elected for the first time a couple years later. And so in 1977, Bill 101, which was the basis for the Charter of the French Language, was introduced. And so the objective behind the charter was really to allow Francophone Quebecers to live and assert themselves in the French language. That said, the enactment of the charter obviously wasn't without controversy as it is today. So, for example, the Supreme Court of Canada dealt a hard blow by striking down provisions that had wanted to declare French the language of legislation in the courts. And so, aside from all of these various legal challenges that the introduction of the bill brought forth, the charter also resulted in a lot of unintended consequences, which we still see today. So, for example, although Montreal was beginning to lose its place as the commercial capital of Canada to Toronto, the introduction of the Charter of the French Language really moved things faster. And it really just solidified Toronto as Canada's commercial capital, with a lot of the headquarters that were traditionally based in Montreal moving to Toronto. And so what we saw when the charter was imposed was that there was changes to everything. So employment rights, the rights of commerce, so that's what we'll be focusing today, the civil administration, school language rights, etc. It's really quite broad. And one thing that's really, really interesting is that the charter also created l'Office québécois de la langue française. So that's what we call the OQLF. Some people call them the French language police, whichever way you want to call it. They've been pretty instrumental in supporting the charter and also enforcing the charter. So that's my history lesson for today. So where are we today? We have Bill 96 that was introduced. Now, it's unclear really what the triggering point was for proposing amendments to the charter and therefore introducing Bill 96. But one thing that is for sure is that the government of Quebec really wanted to improve the level of the French language within the province. And one thing that we saw is that the Office québécois de la langue française, they released a report or a study which indicated that French was on the decline in the province and was significantly declining in the city of Montreal. And so here we are today with Bill 96.
And I have to tell you, thanks, Sarah. That was very interesting, actually. I didn't know all of that history behind Bill 96. But I have to tell you that this subject and this bill has garnered so much interest from our global clients who have brands, global brands, and trademarks throughout the world. Because we're one of the few countries that have something like this happening right now. And not only does it affect, because I do trademark related work, the trademark side of things, but it's the advertisement, the contractual side of things with trademarks involved, the enforcement. And so there's so many areas that it touches upon.
Thank you, Stephanie. And Sarah, thank you for that background. No matter how many sessions we've done around Bill 96, certainly there's always more I learn every time we do this. And I must say your French pronunciation is spot on. Although not that my French is amazing.
I am a Francophone, so there is that.
Then it all makes sense. On that note, I know we talked a bit about the history, but it would be really great to go into the sort of what's changed, what changes Bill 96 has brought about. But before we even get to that, in order for the changes to really resonate, what is the current state and what changed from? And when I say when is the current state, some changes have already come into the effect, but rather, what was it, and then what is happening, what is changing with this bill coming into effect?
So Gary, why don't I start off? I'll briefly touch on the current requirements of the franchisation program, and we'll then discuss product inscriptions before I hand it over to Sarah to cover the current rules around commercial documentation and public signage. So the Charter of the French language states that the use of French must be generalized in all Quebec-based businesses employing 50 people or more. And today, the OQLF, which, as Sarah described, is the provincial agency responsible for the franchisation program, requires that companies with 50 or more employees demonstrate that the use of French is generalized throughout the workplace. Once a company has obtained a franchisation certificate, it must submit a detailed report covering a range of topics such as certain human resources practices and access to bilingual software and broader IT systems to the OQLF every 3 years to demonstrate the continued use of French. The major change with Bill 96 is that the franchisation requirement will now apply to companies with 25 or more employees in Quebec. And according to one stat that I came across in preparation for this panel, the franchisation process will now apply to thousands of businesses previously exempt. Now, companies have until June 1st, 2025 to comply with this aspect of the franchisation requirements. But relatedly, today, a business employing 100 persons or more in Quebec was already required to form a franchisation committee. Under Bill 96, the OQLF may order any enterprise employing as few as 25 persons to form that franchisation committee if the OQLF deems that the use of French is not generalized at all levels of the workplace. And in fact, that requirement, that extension, you could call it, came into force as of June of this year, so June 1st, 2022. And I think just on more of a practical note, it's worth noting that on its website, the OQLF lists companies for which it has refused to issue an attestation or for which it has suspended or canceled an attestation or franchisation certificate, bringing the attention to the public of which companies are no longer meeting those requirements. So switching gears to product inscriptions, today the rule under the Charter of the French language is that any inscription on a product, its container, wrapping, or on the documentation supplied with it must be in French. Other languages can be used provided that they are not given greater prominence than the French language. So in practice, it means that an inscription in English could also appear on packaging as long as it is of equal or less prominence than the corresponding French inscription. And when we think about prominence, we're looking at, like font size, weight, boldness of color, and a number of other factors that sort of contribute to the overall look of the prominence of the inscription. And as we all know, there are a number of exceptions to this equal prominence rule. Most, I think, importantly, the exception around recognized trademarks within the meaning of the Trademarks Act, unless a French version has already been registered. The expression recognized trademark has been interpreted to mean both registered and unregistered trademarks, the latter of which includes applied for trademarks and common law marks. Now, a recognized trademark can be exclusively displayed in English without there being a French equivalent or a generic term to accompany the trademark. And as we'll discuss shortly, Bill 96 will significantly change the ability for companies to use non-French trademarks on product labeling and packaging in Quebec.
And just on that note regarding recognized trademarks, I just wanted to add that so in the past and right now, until Bill 96 comes into play, our clients, if they have a trademark that they're using, and it can be unregistered or registered common law, they wouldn't have to translate the trademark into French unless they had a French registration of that mark, right? And that's all going to change. So even if a mark wasn't registered, you were exempt, right? And out of an abundance of caution, a number of our clients, though, did apply for trademarks because, you know, if the French police did come knocking on your door, you can say, hey, this really is a trademark. We've applied for it, even though we don't have a registration, right? And so that was one of the safeguards that our clients would use.
So maybe just to tackle on a few other things that of like what the existing rules are, at least from a marketing perspective. So we've heard about franchisation, which is, you know, while it might not directly immediately look like to tie into marketing advertising, it does because it's how your company operates, right, in the office, and which can then help make decisions as to, you know, your marketing and advertising practices. So there is a, you know, a really important tie-in there. And then we spoke about inscriptions and how inscriptions need to be in French, but can be in other language. So there's a couple other categories under the charter. So an important one, public signage and advertising. So with this rule, all public signage, posters, commercial advertising, you can think of, you know, any big posters outside, or even storefront signage when you see a store's name. All of those also have to be in French. That said, it could be in French and another language, provided that the other language appears in a manner that's markedly predominant. So this typically means twice as large. That said, there's lots of exceptions. I'm going to just give you one because there's so many. But let's say you've got like a big billboard, right? Like that you can see on the highway, or like you've got advertising inside a bus. So those ones have to exclusively be in French. There's no real rule that you can have it in French, another language, things like that. It's really just exclusive. That said, as we kind of just heard right now, that was previewed, the trademark exemption, and I won't go into too many details there. Let's say you have a storefront and you want it to be, you know, in English only because it's the name of your store and it's a trademark. Think about, I don't know, Starbucks. It's just a big Starbucks logo. So before, if you used a big Starbucks logo, you needed to have a sufficient presence of French. So that's like just a little slogan or something that says what it is. So in French, you'd maybe say café, right? Something small. And so what's changing now is instead of having the small sufficient presence of French, that's no longer small, like it's no longer sufficient presence of French, that addition has to be markedly predominant. So the size of the café would be substantially larger than, say, what it would have traditionally been. So on the commercial advertisement side, so that's television, radio, periodicals, so those things actually have to be exclusively offered in French. They can't be offered in another language unless the media in question is published in a different language. And then the last one that really affects marketing and advertising is commercial documentation. So think of things like websites or your social media pages. I know, social media, which often surprises a lot of people, but those actually also need to be in French, but they can be in other language, provided that the other language, or provided that the French language doesn't appear in a less favorable manner than the other language. So that's kind of what the existing rules were on a marketing perspective, and you know, where they're going today.
And Gary, sorry,
Please go
Gary,
ahead, Mike.
I just want to add on to, for the trademark portion, trademarks are unique in that you don't need to register them. And so that distinction with recognized and registered, where there's other intellectual property that needs to be registered to enforce it, trademarks don't. And there are some very large companies and many companies that have decided for a variety of reasons not to register their marks. So when you look at the change from recognized trademark that Jenna and Stephanie spoke about, that actually has a lot of consequences for these companies that may have been operating for a long time, but have never registered their marks.
And really appreciate that, Mike. One thing and part of this we touched on, but just for because I've also seen new team or new attendees join the webinar. So when can a trademark be displayed in English alone without a French version? So what are some of the examples, like just to have something that, to the extent there are organizations out there contemplating this, what is this? What does that look like?
So do you mean what does that look like now versus what it'll look like once the legislation comes into play?
I'd love to know both. So just to distinguish for the audience, because essentially the way we want to tell the audience, like, here's what you may have right now, and maybe some may not be in compliance already, which is not unusual, but then to know that this is what it's going to get to. And Stephanie, since you brought up the changes, I know I've heard from clients and people we talk to that, well, some of this is not going to come into effect till 2025, so we have some time. So I'd like you to touch on what that timing looks like and what some of that planning could be like as well.
Sure. Okay. So first I'm going to go back with the examples. So
Perfect.
Right now, you just need a recognized trademark, right? So let's say the trademark is Baker McKenzie, the best lawyers, right? And you use that as a common law trademark. You don't have to translate it because you fall under the exemption. And under the new rules, you need a registered trademark. It has to be registered to be exempt. So Baker McKenzie, the best lawyers, would have to be registered. But there's another wrinkle also, because you have to look at the mark and see if there are any generic components or descriptive components to it, because if there are, those have to be translated on packaging and advertising. So if you look at Baker McKenzie, the best lawyers, you may have to translate the best lawyers component of it in light of this new legislation. And what I want to stress is that, you know, like they said, this is going to come into effect in a couple of years, but it takes at least 4 to 5 years now to register a trademark in Canada. So if you're a brand owner and you're thinking of registering now in order to be compliant, it's going to be very, very tough to get a registration before this comes into place. And so you're going to have to, and you know, Mike could discuss this as well, but you are going to have to try and apply in order to, you know, circumvent the translation, apply right now. And there are ways to try to expedite your trademark, and we can go into greater detail if you want.
I would love I'd love a bit more detail, Mike, especially if there's anything else, any further color you want to add. Certainly, and I don't mind if we're a little repetitive on certain things, knowing that some audience team members, first of all, these concepts are not always easy to grasp unless you're in IP law for a living. But secondly, because we had team members join, I refer to them, anyone that is watching the webinar, if they're part of the team for today. So.
Yeah, I can add a little bit to that. The date that I think Stephanie and Jenna mentioned of June 2025 it's a misleading date because, like Stephanie said, the mark has to be registered by then. So getting that registration is tough. And there are some things that you can do to expedite the registration, but even that will be a bit difficult. Like if you're registering a mark, try and register a mark that is very unique or non-descriptive, so that you really get as few objections if possible from the examiner, because you want to really streamline the process. Again, if you're registering the mark, you want to, if possible, Canada has a goods and services manual with some approved goods and services that you could register with. So if you can, try and pick from those instead of creating your own goods and services, which could be a problem if you're working on a global mark, because maybe you want to have the same goods and services globally. That could be an issue. But going through the goods and services, the approved goods and services, you're likely to, I say likely, it's not, not a guarantee, but you're likely to expedite it to get it within that within the time frame and have a registered mark by 2025. It's a weird date because 2025 seems so far away, but you have to ask yourself, what are you doing in 2.5 years? Like, where do you see the brand in 2.5 years, so that you can start planning now, because you need to get those registrations in order to get a registered mark and comply with Bill 96 by the time the June 1st, 2025 date comes around. You don't want to be at that point applying and then waiting a couple more years and possibly have some fines or some issues that I'm sure we'll talk about later on. But yeah, it's really to just get a head start. If you can consider this a head start, get a head start on, I don't know if I would, yeah, I see Stephanie shaking her head. I don't know if I would consider it a head start. Start and get those applications in.
Yeah, and you know, just following up on what Mike said, it's going to be difficult. Like, realistically, it's going to be difficult to get a registration. So not only should you think about what you should be applying for, but you should also be thinking about, what do we need to translate in the event that we do not obtain a registration? What do we have to change our packaging? Do we have to translate generic portions of certain registrations? So even if you do have a registration, you're going to have to consider whether certain components are descriptive and whether you have to translate those. So there's a lot of thought. I don't want to scare people, but right now is a very critical moment.
And Stephanie, thank you. I think one takeaway, certainly from a planning perspective, is even though some of these timelines may seem far away, considering how long it takes for some of this processing, that's why even to Mike's point, is you get started. It's not even a head start. It's just get started, and some of these may not even be in time, but at least the effort being there right away will be useful then, as opposed to waiting any longer. So I think that's an important takeaway. Certainly, one thing I wanted to ask from, and we touched on the generic term or descriptive term for the purpose of Bill 96, but one thing that is that just for the definitions, and again, having people join later, can you give us the definition of what is considered generic term or descriptive term definitionally? And after that, I want us to move to something a bit more specific and tying into a question that came up around product packaging.
Well, I can jump in, Gary, and maybe walk
Please.
through another example.
Yes.
So I can take a personal example. I'm a new mom, and I now spend my very early weekend mornings making pancakes for my daughter, Kaya. And because I'm a first-time parent and also a millennial, I just can't use, the tried and tested true box mix. So instead, I make these things that you can hardly call pancakes at all, because they're packed full of like pumpkin and steamed spinach and organic chia seeds and free-range baking powder, which is not a thing. And I'm not saying I have a name for these pancakes, but let's say I did call them Kaya's Power Cakes. And if I wanted to start a business now and sell those pancakes across Canada with one set of packaging, I would be in a difficult situation, as flagged by Stephanie and Mike, because we know that as of today, it would be very difficult for me to successfully register that trademark for Kaya's Power Cakes before June of 2025. So assuming I was unable to, and I had a pending registration, I would have to translate Kaya's Power Cakes. Sarah, I think it would be crepe santé, but correct me if I'm wrong. But let's just say I was able, and I would have to translate that in equal prominence on my packaging in Quebec. But if I was able to actually successfully trademark Kaya's Power Cakes in English only, and I was selling packaging into the province of Quebec, I would need to still include a French translation of the Power Cakes piece. So again, I think there's a gap here in the guidance today around how the size, I guess, or the prominence of that French translation of the generic or descriptive term that forms part of a registered trademark. And I think that more regulations are coming to provide more guidance on how exactly to interpret what a generic or descriptive term as part of a registered trademark would be, and how to comply with the level of prominence. And yeah, I, like so many others, am hoping for that additional guidance so that
Right.
I know how to take care of the packaging for these pancakes.
And exactly. So there's going to be more guidance in terms of what is generic and descriptive, but like Jenna stated, so Power Cakes. So these are terms that other people should be entitled to use in the industry. So, you know, if I say Baker McKenzie, the best lawyers, you know, we shouldn't be the only ones entitled to use it. It's a very generic term. You'll see it in, you know, titles of magazines, you'll see it elsewhere. And so we shouldn't have a monopoly on that phrase. And as a result of that, it may be considered generic or descriptive. So you need to translate that portion of the mark.
So maybe just to quickly add, as Jenna noted, so we haven't received any guidance yet. We do think that there is some guidance, whether it's in the form of regulation or guidance on the OQLF website, but we expect that the generic term concept is going to capture things like product variant information. So if we're thinking about personal goods, this could be the smell or the flavor of a product. If we're thinking about consumer goods, this could be like a slogan like Stephanie mentioned, the best lawyers, which we are, right? That was a joke. But one thing that's interesting that I really wanted to raise is that while we don't have any additional information, we did receive a little snippet of guidance as part of a legislative debate. And so during that debate, a legislator gave the example of a soft soap product, and that's essentially like a liquid gel soap that I'm sure many of you have already seen it. But what was interesting, and I'm just going to read here, is that the packaging, as part of the trademark, it said soft soap brand lavender and shea butter washes away bacteria, deeply moisturized to hydrate skin. So all of that is the trademark. And so in this debate, they mentioned that lavender and shea butter washes away bacteria, deeply moisturized to hydrate skin should all be translated. So, you know, it's not the guidance we want, but it's something, and it's really important to see, you know, how far they want us to go with this whole concept of generic or descriptive terms.
And Sarah, and we've already had a couple of attendees ask questions. I'll use this opportunity to invite, if any of the audience has questions, feel free to put them in the Q&A, and I will introduce them to the panel wherever possible, and perhaps even do some at the end if we couldn't get to them. But Sarah, just on that note, because you know, we've seen the shortage in medication packaging, and this is a question from the audience, and also this is largely driven allegedly by the bilingual requirement for packaging labeling. What could be done? Like, is there anything? I mean, this presumably could have been something that would have been the case even before this changes. So I wouldn't necessarily attribute this to Bill 96. But any suggestions? What can manufacturers do? Is there anything that can be done?
Yeah, that's actually a really, really good question. And you know, I think we need to maybe first lay down some differences, because what's interesting about this issue is actually triggered by federal labeling requirements and not Quebec labeling requirement. The reason why this is even more interesting is because federal labeling requirements are significantly less burdensome than Quebec language requirements. And so on this basis, it's easy to see how, you know, having very strict labeling issues can result in, you know, dire situations. So what's really interesting here is that as a result of these children's cold medicine shortages, which are actually due to a number of reasons, but obviously French or bilingual labeling exacerbated the issue. Health Canada actually issued a notice that it was waiving some of these strict bilingual requirements, as well as other labeling requirements to actually allow medication from the US and other countries to enter the country. So what's interesting here is that we haven't necessarily seen the same thing happen in Quebec with the OQLF. At least I haven't. It's possible, but I haven't. And perhaps Health Canada and OQLF, have some sort of agreement. But if we're seeing this on a national level for federal labeling requirements that are really not that burdensome, this makes us really think about what do we need to do for requirements in Quebec, which are even more burdensome. And I think, we're going to really have to start thinking about what we do. Is it a matter of restickering? Is it a matter of having labeling operations in Canada, but bringing the product in from elsewhere? There's a lot of areas we can talk about, and I think we're going to discuss some of these in some of the other questions. But one thing I really wanted to flag is that there's the real potential that these types of really restrictive rules can result in what we've seen with contest over the years. I'm not sure if a lot of you on the line are very familiar with contest rules, but they are the same across Canada except for Quebec. And in Quebec, there's all these rules that you have to register, that you have to have a reporting obligation, that you have to pay certain fees. And so for the most part, you see a lot of businesses saying open to residents of Canada, excluding Quebec. So are we moving in that direction? Is that what's going to happen? It's something that we'll really need to consider. And I think an important thing, just to tie up this train of thought, is that right now we typically see national retailers taking the position that if they take on a product, they're selling it across the country, Quebec included. And so it's one thing that, I'm wondering now, is this something that they're going to change? Is this something that they're going to say, well, maybe we'll make this exception now that you can sell in Canada and not Quebec? And so again, I don't have answers for these questions, but these are all things that we should really be thinking about in discussions that clients and businesses should be having with their retailers and things of that nature.
And Sarah, you brought up OQLF. So one of the questions that I thought about for the group is there's obviously new enforcement powers with Bill 96 that are being given to OQLF. Any thoughts on, do you think OQLF, and again, although Sarah brought it up, not opening this to the group more broadly, are there any, what do you think the enforcement is going to be like? Do you think there will be more rigorous enforcement in light of this? Are they being given powers that have more teeth, so to speak, than before?
Well, Gary, why don't I briefly cover the enforcement regime? So businesses that use unregistered non-French trademarks in Quebec do expose themselves to sanctions ranging from $700 to $7,000 for individuals and between $3,000 and $30,000 for legal entities, and fines for a second offense or double, fines for subsequent offenses are tripled, and each day of non-compliance is considered to be a separate offense. It's also, I think, worth noting that for the 2020-2021 fiscal year, the OQLF was given a significant budget increase. It was around $5 million, which, to put into perspective, resulted in a 28% budget increase, which is the largest budget increase that agency has seen in more than 25 years. So I think that companies need to see this as a signal that this is an agency that's being supported and budgets are increasing. And so enforcement is likely to be seen as a real priority.
Thank you, Jenna. We appreciate that level of detail as well. I think certainly the additional funding and the level of fines is an indication of that this is a serious measure, and it's an opportunity to really think of compliance in advance, as Mike and Stephanie suggested. So I have some specific questions from the audience as well, but on the product labeling side, what does this mean for the business that operate in a cross-border manner? There's a question that came up from the audience as well, but just how does this play out for anyone wanting to do this? And I know Sarah touched on it a little bit, but any further thoughts on it?
I could probably take that one. Or Jenna, did you want to take that?
Why don't you start, Sarah, and I can chime in.
Great. So, there are rules about when the charter will apply. And so they can get a little bit difficult. So I won't get into, whether your business is subject to the charter or not. But generally, if you are targeting Quebec consumers, whether online or not, there's a high likelihood that, an analysis will result in the charter applying to you and you being subject to these rules. But we're seeing a lot of changes. For example, this one was interesting because I saw this one all over the news. Was an example of OtterBox, which is a cell phone case manufacturer company. And they actually just added a message on the top of their website that says it's just temporarily suspended shipments into Canada due to Bill 96. So if you go there and you try to buy, it is just a big sign. So that's just one example. And maybe Jenna has other thoughts about, how this is operating cross-border from an in-house perspective.
Well, I can speak more broadly, I think, from what I'm seeing and hearing within the marketplace. I think this is realistically quite a challenge for businesses potentially operating in a cross-border manner, not just cross provinces in Canada, but a lot of times you see, if you walk down any grocery store aisle, you can see signals that the same packaging is perhaps used in Canada and the US. And so if you're a company that has a cross-border portfolio, you may find yourself assessing the size of the Quebec market and considering the impact of Bill 96 on packaging. And I also just wonder if businesses will perhaps consider over-stickering for the Quebec market. I know that presents a number of supply chain challenges that Sarah has touched on, especially with retailers, and sometimes that might not be realistic, but and my advice, I think, on this point would be to engage early and engage now with cross-functional stakeholders within your business. There's a lot of expertise to be gained from engaging with packaging and supply chain experts and marketers. And I think really when it comes to compliance, the most effective approach is a top-down approach. So I think that in-house lawyers need to be briefing their leaders and thinking about the financial or potential financial impact. And, we've already heard from Stephanie and Mike that we're short on time now. So making a compliance program now and engaging with your leaders to have that buy-in across the business is really going to be important when you think about strategizing for cross-border and cross-Canada compliance.
So some of the questions from the audience are really tying in around potential legal challenges and what if there are any lobbying efforts from industry, et cetera. What have you seen out there in the marketplace? Is there pushback from industry? Is there, what types of legal challenges have you seen so far?
Well, from a trademark perspective, I can tell you that the International Trademark Association is one of the organizations that is in fact lobbying, the CBA, individuals, brand owners, global brand owners are also lobbying. And there are a number of concerns, and I'm just going to touch upon some of the concerns from a legal perspective. So one of the concerns that is being brought up is, well, you have this trademark that is registered, and if it has generic components and we have to, translate some of the generic components, will that trademark be vulnerable because you're not using the trademark as registered. And so in Canada, if you don't use the trademark as registered, it could be vulnerable to cancellation 3 years, after the registration, technically, right? So there's that issue. Like, are you using the trademark that you registered? And are there issues associated with that? Another issue that has been brought up is, with respect to the courts and the tort of passing off. So the tort of passing off, you do not need a registered trademark in order to advance that, right? And as long as you use your trademark in certain areas across Canada, you have protection. So now, with Quebec and the fact that you need a registered trademark, is Quebec going to be carved out of this remedy, right? And others are saying, well, this is completely against treaty obligations. So there's so much lobbying on that side of things, but an interesting, I'm also seeing lobbying to the trademarks office to try to expedite registrations, right? And to assist and possibly provide an exemption, and have applications examined quicker because you need to comply with the French language laws.
And Stephanie and Mike, if I could pick on you and then obviously open it up to Jenna and Sarah as well. So we've talked a little bit about the various definitions as well as the changes that have come in. Let's say I am a GC at a large organization. I have a whole bunch of trademarks. Where do I pick this up from? Like, help me put a plan together. Like, how do I come up with a plan to make sure I've tackled this properly? What are some tips you would have for me that I can prepare this? And obviously some of the audience will be in legal departments and some will be in business roles. But regardless, I think the strategies would be similar.
I can start with this one. And I'm going to pull from what Jenna said. I think it's very important to have a cross-functional team of stakeholders. Like, this is, although it's a legal issue, it's a business issue, and it should not just be the legal team looking at this. Like, you really need to bring in anyone who's associated with it. But from the trademark perspective, you need I think the first step would be conducting an audit of your mark. So do you have registered marks? Do you have unregistered, or do you have common law marks, or do you have a lot of marks that are currently pending registration? You just need to get an idea of what is the status of your marks. And then, like we mentioned earlier, figure out what you want to be, what your brand will be, and what marks you want to register by 2025. What do you expect to have out there, so that you can determine what you want to register, and also how to register the common law marks that you have. And prioritize, I would suggest prioritizing those common law marks, especially if you've been using it for a while. That's something that you should really prioritize, because you want it's likely like your house brand, and you want to continue that. When it comes to registration, I think I mentioned this earlier, try and create marks that are sort of unique so that you don't really get those oppositions, and also use the goods and services manual. But it's really that beginning step of looking at what the marks that you're using are. What do you plan on using in the future? And I mean, the future is really not that far away. So, and see what you can do to get those out there, and also consider which marks you have registered that are also registered in French, because that's another concern that you have as well.
Yeah, and just to add to what Mike said, look, we appreciate that it's very, very expensive to apply to register every single mark, in order to circumvent, Bill 96. So you have to consider and tier it. Maybe say, okay, these marks we're not going to register. They're only going to be, on the shelf associated with product for a couple of years. So maybe we don't have to even apply for those. But if they're going to be on the shelf for more than a couple of years, then maybe we have to think of a French translation, right? And then that also goes into the issue of, well, even if you translate the English portion, do you have to do and conduct a full search, trademark search, to see whether or not it's available? More often than not, it should be available because French, we're bilingual. However, that's another consideration that you should talk to your legal team about.
And thank you, Stephanie. Pending any other comments from the panelists, I have a question from the audience actually that really ties into some of the definitions we touched on earlier on descriptive and generic terms. So the question is, do you have any direction about whether or not to translate trademark loyalty or subscription programs like Amazon Prime, Anthropology Anthroperks, IKEA Family, where Prime, Anthroperks, or Family are somewhat descriptive but not quite generic? So this is a sort of a very specific question, but I think it's illustrational around the definitions that we were touching on earlier.
Yeah, maybe I can start with this, and then if anybody maybe on the IP side has any other thoughts. So one thing about the charter, there are certain exemptions. You know, we really haven't spoken about everything under the sun, even from a marketing and advertising perspective, but there are exemptions. So things like made up words or family names or names of places, there are certain exemptions of what can remain in English even without a trademark. So something like an anthroperk, well, is that really a word? Probably not. So something like this, there's possibility that you can rely on maybe one of those exemption, and that the generic term might not necessarily come into play, and that you wouldn't be required to translate that. But you know, something like Prime or Family, that's a little different, right? But again, we don't have any direction, we don't have any guidance, we don't know when we're going to receive any of that to really be in a position to know whether it's descriptive, at least from a marketing perspective. But you know, it might be a different position from an IP perspective.
So another interesting question to the extent that the panelists have an answer. So does this apply to business that sells its products to the residents of Quebec, but the business are headquartered outside the province or even outside of Canada? Let's say they're selling via an online website. Would this apply just the same? I know it's getting a little specific, so certainly some
Sure.
of these.
I could probably take this one again. So, and I kind of briefly mentioned this. So we need to know a little bit more about how the business is structured to, you know, actively take the position that the charter applies. But typically, even if you know, there are arguments that if you're not in Quebec, there's a possibility that it might apply to you. Generally, if you're, you know, located in Quebec and you're selling to the Quebec consumer, it's pretty clear. But when that's not the case, there are certain extenuating circumstances that could result in the OQLF taking the position that the charter does apply to you, even if you're selling online, not in Quebec.
Thank you, Sarah. And I think sort of broadly, the advice is if you're selling to Quebec residents, regardless in any form, it's just good business to have a French version. And that way, even regardless of what position OQLF takes, it's a good practice and client-friendly. Statistics show that online sales will do better when done in the language that you're catering to. So just I know there's a lot more questions, so I wanted to ask a couple more from the audience, and then just for the panel, I want you to, as I ask a couple more questions from the audience, think of some last parting thoughts. We only have 7 minutes left, so I'm conscientious of time, and as we were preparing for this, we said time will fly by. So what I'll do is 2 more quick questions for you, and then what I'd love for you is any sort of roundtable parting thoughts, what tips you can leave the group with just as they prepare in light of this, or anything that you're like, I didn't get to this, but this is very important to let them know, because naturally the moment you go through this, we can rush a little bit. So the one of the questions that came up was around if a business expands its goods and service offerings, can it rely on a registered mark covering a narrower scope of goods and services for the exemption? And an example is registered baker, the best lawyers for legal service. Can I then rely on the same mark for software as a service? I know again we're getting into specific territory here, yeah, but to the extent that you'd like to speak.
But if you are using it with software, So I'm assuming the question is you have a registration with specific goods and you want to know if you could use it with goods that are outside, avoiding the translation. I mean, it is very specific. You'll have to determine what the goods are, if they are related. And then sometimes you might not even be able to use that same registered mark with completely different goods without doing a search to make sure that you can do that. So I'd be more than happy to address this offline with further specifics.
Thank you, Stephanie. And I am a little worried that we're not going to have a chance to do a full roundtable before, because we're now in the last 5 minutes. So one thing that we discussed with the group here, the Baker team is happy to have any questions, chat with you offline on some of the more specific items. But I want to open it to our panelists for any last minute thoughts. So suggestions, whether it's around how to prepare, any sort of tidbits of what's coming that was really important that we didn't get to. Certainly when you fly through in an hour and try to cover so much ground, the hour flies by. And you can go in any order you'd like. So.
Sure, I can start. I think we've alluded to this, but I think that lawyers aren't the only ones to play a really valuable role in, I think, helping navigate Bill 96. So I think that it's really important to involve your marketers. I think they could be a really key resource. So make sure they're briefed on what we know today and push them to get creative, to think about cleaner packs, to manage space constraints around bilingual claims. And I'm curious to see what could possibly come out of this. Like, are businesses and marketers potentially going to use more imagery to convey messages to consumers, or come up with claims that are just inherently bilingual, like numerical claims? I also think, a lot of non-legal colleagues might be members of industry associations who are potentially already pushing for additional clarity and guidance around Bill 96. So make sure you're connecting internally with your other colleagues who are potentially already getting involved.
Thank you, Jenna. Anyone else from the panelists?
I'll speak to the trademark perspective. I've mentioned this before. I'll mention it again. It's try and get ahead and get started on your trademarks. If you know what you want down the road, try and work with your team to get those registrations through and those applications in. But this is a unique situation where the date is 2025, but there's a lot, as Stephanie mentioned, there's a lot of lobbying going on. So we're hoping to see some exemptions and changes to this and regulations. So this is something that your legal team should stay up on, just to make sure that you're aware of any changes that come through. Because again, like there's a lot of lobbying from different organizations and clients and things and customers. So it's a unique situation.
And just to add on to what Mike said, I mean, we haven't addressed all the exemptions as to how you can expedite a trademark application. So, talk to your legal team, because there are certain exemptions, you might fall within them. And so it's not, it might not be too late for some organizations to get a registration.
And I guess just the last thing I would like to just raise here is one thing that we've really noticed as a common theme as a result of the introduction of Bill 96 is that a lot of our clients and other organizations didn't necessarily know the extent of what they needed to do to be compliant with the existing laws. And so we've been helping a lot of our clients, never mind figuring out how to deal with Bill 96, but just making sure that they're actually meeting the requirements under the charter today. And so my one piece of food for thought, for the end is, as you begin to consider what you're going to do from a marketing and advertising perspective in the next 3 years, it's probably a really good idea to also consider doing an audit of what you have, whether it's your website. We're seeing a lot of our clients, they're realizing that, their website, or they get a notice from the OQLF about their website. So, think about your website. What's on your website? Do you have videos on your website? Have you thought that to, make sure that they're dubbed? Are you thinking about your social media? Are you thinking about the advertising that you do? Are you having sponsored posts on Instagram targeting people in Montreal? You know, it's really important to really start having these conversations because you know, it's great to be prepared for Bill 96, but you can only be prepared if you're already doing what you need to be doing today. So my big piece of advice is to really do a deep audit, make sure that your practices are in line, and this will put you in a better position to tackle proposed changes till Bill 96. And while the legislation is passed and we don't necessarily, at least from the provisions we talked about today, don't necessarily expect to see, you know, big changes necessarily. Maybe the lobbying efforts might, you know, add some relief in some instances. I think it's pretty clear that this is probably, at least for these provisions, it's probably going to proceed. And so we should be really mindful of what we need to do. And the reason I wanted to say that is because a couple of years back, there was you know, similar changes to the public storefront signage rules, which, you know, came with a blink of an eye. And, you know, a lot of people weren't happy about them, but they passed and it resulted in stricter rules and more limited use of trademark exemptions. So I think it's pretty clear that we're going in that direction. Perhaps other parts of the legislation or the bill or other statutes that the Bill 96 affects may change, but for purposes of this conversation, likely not. So as everyone said, you know, look at what your trademarks are, but also look at what your general marketing and advertising practices are today. Thank you, Sarah, and to all the panelists for the great insights for today. Sarah, I'll contact you offline to help me put a checklist of all our IP items that I need to do for the inventory and prepare. But we are committed to keeping you informed on this. The next webinar will be at the end of January, preparing for commercial agreements as they relate to Bill 96. And thank you to all the audience for joining us today. I know we're a little bit over time. Please feel free to reach out to any of the Baker team. They're happy to chat with you offline. And thank you all for making the time today. Bye, everyone.
Bye, everyone. Bye.